Okay, I'd like to welcome everyone to our What Are the Experts Saying webinar. Today we're going to talk about labor and employment, and specifically a Labor and Employment Law 2015 review. So welcome everyone. We're so glad you can be with us. My name is Jenna Ellis, and I, along with my co-moderator, Dan Tatello, will be your moderators for the day. So you'll hear both of our voices along with our experts during the webinar. If you have any questions, maybe for our experts, or if you're having any difficulty, you can go ahead and send a private chat, and you should do that to Dan Tatello. And up at the top of your screen, there'll be a drop-down, and you can select chat, and then it says send to, and you'll want to select Dan's name and send him a private chat, and we'll take care of any questions that you may have for Pam, our expert, at the end of the webinar if we haven't covered it. So with that, I am so honored to welcome Pam Wolf. Pam is our featured expert today. She's an attorney and legal analyst. She tracks and analyzes labor and employment law issues, court decisions, and of course trends for Wolters Kluwer Employment Law Daily. Welcome. Thank you so much for being here, Pam.
Oh, it's my pleasure, Jenna. And let me just add that I did have some technical difficulties earlier, and I'm in an area that is not quite as soundproof as I'd like. So I'm going to hold my voice up, and I hope there will not be any extraneous background sounds. If there are, I'll apologize for them in advance.
Okay, sounds good. We're glad you're on with us. I know technical difficulties are hard to overcome sometimes at the last second, so I'm glad you're here with us. So our overview today, or just to kind of get you acquainted with some of the topics we'll go over, we're going to start with joint employer, and that definition is in flux, and Pam will tell us a little bit about that. And then we'll look kind of on the other side of the fence and look at who really is an employee. And Pam will talk about that definition, what's changing there. Then we'll move to what is new on the regulatory front, or what happened in 2015 in the regulatory front, and move to a conservative Supreme Court this year. Seems to be pretty employee-friendly, and Pam will give us an overview of some of their decisions. So with that, Pam, do you want to start with the joint employer info?
Yes, and you know, I think this is the topic that may have garnered the most attention in the labor and employment world last year. That is the changing definition of joint employer. And the definition is in flux not just at the National Labor Relations Board, but also at the Labor Department and at OSHA. So it's really no secret that employers have changed the way they do business, mostly due to economic and market factors. And federal regulators are, of course, very interested in making sure that the standards they apply to determine who is liable for a particular violation are in sync with current business models. So, employers and many lawmakers are pretty worked up about the Labor Board's modification of the joint employer standard that had been in use for quite some time, decades, literally. As the board sees it, though, they have merely returned to an earlier test and the application of traditional principles of agency. So what is the new test? There are joint employers when there are two or more statutory employers of the same joint employees if they share or co-determine those matters governing the essential terms and conditions of employment. The threshold inquiry here is whether there is a common law employment relationship with the employees in question. If so, the next question is whether the putative joint employer possesses enough control over the employee's essential terms and conditions of employment to permit meaningful collective bargaining. Critical is the question of how control is manifested in a particular employment relationship. Now, under the old test, to be a joint employer required both the authority to control employees' terms and conditions of employment and also the exercise of that authority. That is no longer the case with the new test. Under the old test, Control also had to be exercised directly and immediately. That too is no longer true under the new test. Now, if otherwise sufficient, control exercised indirectly, such as through an intermediary, can be enough to establish joint employer status. And this really is quite a big change. Why is it a big change? Because, for example, the board has determined that McDonald's, the corporate enterprise, may be a joint employer along with its franchisees. Now, this has caused huge ripples in the business community and among many lawmakers, particularly with regard to its potential to have a negative impact on the franchise community, which tend to be small business people. The development also quickly gave rise to congressional hearings as well as legislation that is aimed at rolling back the board's new joint employer test. And we haven't heard the last of that for sure. On the other side of the fence, those who support the new test say that with the changes in business models and so many companies renting workers, low-wage workers' rights are really being trampled, and it's really tough for regulators to figure out exactly who should be held liable. Notably, OSHA has also floated a controversial internal draft memo that ponders a joint employment relationship between a franchisor and a franchisee so that both entities could be liable under the OSH Act. That memo includes a checklist that inspectors can use to determine whether there's a joint employer responsibility for safety violations. Along similar lines, the Department of Labor is interested in what it calls fissuring practices. In its first successful case, DirecTV entered into a consent judgment under which it paid $395,000 in back wages and damages to 147 cable installers. That came after a court was convinced that the company had used fissuring practices in an effort to avoid responsibilities under the Fair Labor Standards Act. So what was the problem? Well, DirecTV and its installation subcontractor paid the employees on a piece rate basis. That resulted in their hourly rates falling below the federal minimum wage. They also were not paid for all the hours they worked for overtime, nor were they paid for time spent on unsuccessful installations, travel time, and time in the office. So, why was DirecTV a joint employer? Well, the installers worked only on DirecTV installations. They had all conditions of employment specified by DirecTV. They drove DirecTV vans. They wore DirecTV clothing. So the court ruled that DirecTV was indeed an employer of the installers and as a joint employer was responsible for any violations that the workers suffered. You should also be aware that just this past Wednesday, the Labor Department's Wage and Hour Division issued interpretive guidance on the joint employer test under the Fair Labor Standards Act. Again, the Labor Department was concerned about these fissuring practices. And the test they outlined is a very broad one. It's broader than the common law test. It's broader than the test used under the National Labor Relations Act, and it's broader than the OSHA test. And some courts have already followed the trend of modifying the test for joint employers. For example, the Fourth Circuit has applied the hybrid test for joint employer status under Title VII, which considers both the common law of agency and the economic realities of employment. Using its modified test, that court reversed summary judgment on a temporary employee's Title VII sexual harassment claims. The court found she was jointly employed by a staffing agency and the automotive parts manufacturer to which she was assigned. Although the staffing agency paid her checks and formally fired her, the manufacturer nonetheless supervised her day-to-day activities. They asked that she be removed, and they otherwise exercised substantial control over her employment. And a federal court in New York recently granted, well, last year granted the Labor Board's application for judicial orders requiring certain McDonald's franchisees to comply with subpoenas for documents related to whether McDonald's was a joint employer of the franchisee's employees. This battle is still going on, by the way. There, the board had shown a reasonable connection between its inquiry into the existence of a joint employer relationship between McDonald's and the franchisees and the board's investigation of unfair labor practices at the franchisee's restaurant. A federal court in California did agree with McDonald's that it did not employ employees at franchisee restaurants for purposes of California state wage claims, but the court nonetheless allowed employees to proceed against McDonald's because of fact issues that existed under an ostensible agency theory. And that's because the employees believed that McDonald's was their employer. They wore McDonald's uniforms, they served McDonald's food in McDonald's packaging, they received pay stubs and orientation materials that were marked with McDonald's name and logo, and almost all of them applied for the job through the McDonald's website.
Sorry, I was on mute. So, Pam, we kind of talked at the beginning of looking at the other side of the fence. So when we look over there, what happened in 2015, kind of on the employee-focused side?
Yeah, Jenna, so not only were we taking a fresh look at who is an employer, we were also examining the other side of the equation, as you've mentioned, exactly who is an employee last year. And we'll start with one of the stars of the so-called sharing or gig economy, and that's Uber. And decisions have come down on both sides of the fence as to whether Uber drivers are employees or are in fact independent contractors. In March, the California Labor Commission ruled that Uber drivers are employees and not independent contractors. The Oregon Bureau of Labor and Industries, in an advisory opinion in October, came in exactly the same way. But the Florida Department of Economic Opportunity said, and I quote, "Uber is no more an employer to drivers than is an art gallery to artists." And the California federal court saw it a little bit differently, finding Uber drivers were presumptive employees, and that as to any particular individual, the question is really one of mixed law in fact that typically needs to go to the jury for resolution. And I'll add here a very recent development. I think it was late yesterday. Lyft, which is a service similar to Uber, has just agreed to give its drivers greater workplace protections, but still without classifying them as employees. And this would end class action litigation. This is a $12.25 million deal, so it still has to be approved by the court, but this is a big, big issue, and there is a continuing trend of class litigation, getting at exactly these problems. And perhaps in a perfect sign of the times, the Seattle City Council unanimously approved a bill that gives eligible drivers at taxi, for-hire, and transportation network companies, just like Uber, the equivalent of collective bargaining rights that they would not otherwise enjoy. This bill creates a process whereby a majority of independently contracted drivers working for the same company can choose to join a driver representative organization whereby they can negotiate the pay rates and terms and conditions of their employment, which is really a very positive development in the alternative labor world. And just to throw a little something in here, Seattle is becoming a little notorious. Recently, the International Franchise Association filed a petition for cert in the Supreme Court challenging Seattle's $15 an hour minimum wage law, which would treat franchisees as large employers, so that they would have to be phased into ultimately paying $15 an hour more quickly than would other small business owners. So it's a big issue. So the employee versus independent contractor question also played out last year in the context of FedEx drivers. Last May, the 11th Circuit reversed summary judgment granted to FedEx by a federal court in Indiana that was presiding over multi-district litigation. Here the court found that the question of whether FedEx drivers are employees or independent contractors ultimately must be decided by a jury. So that's similar to what our California court found earlier. Significantly, the court found the agreement between the parties, which specified that drivers were independent contractors, was not determinative because of that conclusory language. There were other contract provisions and procedures that gave FedEx control over delivery procedures, uniforms, and truck specifications, among other things. The language in a contract that says you agree that you're independent contractors may be seen by the courts as merely conclusory and just may not accomplish what the employer wishes. In Kansas, however, FedEx drivers are employees. Their FedEx lost in the 7th Circuit, which held in July that although FedEx disagreed with the Kansas Supreme Court's conclusion that its full-time drivers were employees under the Kansas Wage Payment Act, that state high court decision was determinative, and its finding that they were indeed employees was binding. So let's talk now about the question of whether trainees and interns are actually employees. That's another one that has been playing out during the course of last year and even before then. In July, the 2nd Circuit rejected the Department of Labor's 6-factor test under the Fair Labor Standards Act and adopted instead the primary beneficiary test. The appeals court set forth its own non-exhaustive list of factors that must be considered in determining which party gains the primary benefit of the internship. The 11th Circuit, agreeing with the reasoning of the 2nd Circuit, also scrapped the Department of Labor's 6-part test. Finding the test too rigid, the 11th Circuit remanded the case for further development of the record with respect to the particular clinical program that students were required to take for their degree.
So what about, thanks Sam, and that's a lot of stuff, a lot of great stuff on the employer-employee front. And so what about switching to the regulatory front? What happened in 2015 and what's kind of carrying over into 2016?
Well, you know, of course, employers are always very concerned about what changes may be in store on the regulatory front. They much prefer a stable regulatory environment. They don't like surprises and changes for understandable reasons. So there was considerable uncertainty as to some of the regulatory changes that employers might be facing in 2015 and going into 2016. I think most notably with regard to the Labor Department's so-called white-collar exemption. The proposed changes to the white-collar exemption regulations were long anticipated and finally came out in June. These are the regulations that define the executive, administrative, professional, outside sales, and computer employee exemptions from overtime pay under the Fair Labor Standards Act. The most significant change to the regulations would more than double the current floor below which the white-collar exemptions would not apply, taking it from $23,660 to $50,440 as projected for 2016. It would also increase from $100,000 to $122,148, the pay required for highly compensated employee exemptions to apply. The proposed salary floor is set at the 40th percentile of weekly earnings for full-time salaried workers. The big change in the salary floor, I think, was largely anticipated. But a novel element that was not much anticipated was that for the first time under the proposal, the Department of Labor would establish a mechanism by which the salary thresholds and highly compensated employee floors would rise automatically going forward. So the agency is seeking input on whether that rate ought to be indexed to the Consumer Price Index or fixed at the level of the 40th percentile of full-time salary workers in a given year. And the duties test was not touched in the proposed regulations. There was a lot of concern over that, whether that would change. But I think it's likely that change is on the horizon because the Labor Department is soliciting comments on whether the duties test should be changed, and if so, how specifically it should be changed. I think that does implicate some procedural questions under the APA, so we'll have to see what happens in 2016 with regard to that particular aspect of the regulation. Some people feel the Department of Labor is setting itself up so that it can very quickly make proposed changes without having to go through the normal process, or at least the process that we've been used to up until now. So moving on, another pair of proposed regulations that many employers were concerned about touched on how they could structure their wellness programs while still being compliant with the Americans with Disabilities Act, as well as the Genetic Information Non-Discrimination Act. Under the ADA, as most of you are aware, I'm sure, employers must be very careful about when they can ask disability-related questions. And under GINA, employers are restricted from asking about genetic information and history. In April, the EEOC released its proposed ADA rule. The big question employers had was how much of an incentive they could offer for participation in programs. Under the proposed rule, companies may offer incentives of up to 30% of the total cost of employee-only coverage in connection with wellness programs. Under the EEOC's proposed GINA regulations, which came out in October, the total inducement is likewise capped at 30%.
And so, Pam, let's move to the Supreme Court. And something I mentioned kind of at the top of the hour that was interesting, especially for a lot of the court watchers, is that this is what people would probably call a conservative Supreme Court. And in 2015, they seemed pretty employee-friendly, right?
Yes, that's absolutely true. I think most would agree that we currently have a conservative Supreme Court, but in 2015, the court came out with 3 rulers that really impacted the labor and employment law arena, and all 3 of those rulings were considered employee-friendly. And before we move on to those rulings, I do want to say that the Supreme Court also did come out with this Obergefell versus Hodges ruling, which basically said that states may not bar same-sex marriages. While that does not directly impact the labor and employment law arena, certainly the repercussions of the ruling do in terms of expansion of anti-discrimination protections that we're going to continue to see and treatment of benefits. So, moving on to the first Supreme Court ruling that was employer-friendly. It was the one that I think employers were most interested in, and that is the Mac Mining case. In April, the justices unanimously ruled that Title VII does authorize judicial review of the EEOC's efforts to satisfy its statutory duty to try and conciliate charges before filing suit against the employer. However, the court held that the scope of that review is narrow, and the remedy for the agency's failure to attempt conciliation is a court order requiring the EEOC to undertake its mandated efforts. It's not dismissal of the case, as many employers would have preferred. So in some respects, I think the EEOC feels greatly enheartened by this ruling. A second ruling was the Young versus UPS case, in which the Supreme Court applied the McDonnell-Douglas burden-shifting standard to a UPS driver's Pregnancy Discrimination Act claim. She had asserted that UPS accommodated the lifting restrictions that employees with on-the-job injuries or disabilities had, but across the board unlawfully refused to accommodate pregnant employees lifting restrictions. And in that case, it was a light duty restriction, I think, of not being able to lift more than 20 pounds. Finding a fact question as to whether UPS had given more favorable treatment to at least some workers whose situations could not reasonably be distinguished from the employee situation, the court vacated the Fourth Circuit's ruling and left it for the appeals court to determine whether there were issues of fact as to pretext. Notably, the Supreme Court, in its opinion, disagreed with what was then the EEOC's position on what constitutes pregnancy discrimination under Title VII. And accordingly, the agency was forced to go back and modify the Title VII part of the pregnancy discrimination guidance that it had issued in July 2014. The third employee-friendly ruling that I want to talk about briefly is EEOC, the Abercrombie and Fitch stores. And this was over the retailer's refusal to hire a Muslim applicant because her headscarf conflicted with the store's look policy. The court found the refusal to hire the applicant violated Title VII. Importantly, the justices ruled that Title VII does not impose a knowledge requirement. Further, the court ruled that religious practice cannot be a factor in any employment decision.
Okay, so Pam, during this webinar we talked a little bit about some of the things, that happened in 2015, but also what you're looking forward to in 2016. What are some other issues specifically you're looking ahead for?
Well, Jenna, I think that in 2016 we can expect a continuation of much of what we discussed today, and I would break it down into two areas. First, the employee-employer relationship, and secondly, how employees will work together to get better terms and conditions of employment, regardless of how they are classified. As to the first area, I think we'll continue to see federal regulatory agencies and courts trying to catch up with evolving 21st century ways of doing business, particularly with regard to who is an employer and exactly who is an employee under various federal statutes. Federal regulatory agencies and courts are going to continue to examine, displace, or expand current tests for determining the employee-employer relationship. And I think we'll see continued legislative efforts to keep federal regulatory agencies in check as they develop more expansive interpretations of that relationship. On the second front, workers will continue to find non-union types of approaches to collectively seeking better terms and conditions of employment. That's because the new business models, some would argue, are aimed at reducing wages and benefits that are considered costly for employers, but are also highly valued by workers.
Great. So thank you so much, Pam. Dan, I'm looking through the chat. I see some things that we've already covered. Are there any other questions that you see?
No, I don't think there are any questions that we haven't answered. I did just want to point out the Employment Law Daily, because Pam is a frequent contributor, and we have many of the stories that we put here, when folks ask for a copy. Many, I think, of the people registered already have the Employment Law Daily, but if you've never had a chance to see it, I just wanted to put our URL up at the top, and just point out that, of course, this is a free trial period if you wanted to see some of the stories and the coverage that we have, and that's in our Employment Law Daily publication. That's what I wanted to point out. I'll pass it back over to you, Jenna.
All right. Okay, great. So thank you so much, everyone. Some of the questions are always, can I have the PowerPoint presentation? And the answer is yes. We will definitely send it to you. So look for an email. It'll have these slides, and it'll also have a really brief survey. It takes, 2 minutes to fill out. It's very helpful to us in choosing future topics. So we'd really appreciate your help in just completing that really brief survey, and that will be emailed to you along with the slides. Thank you so much for your time. Thank you for being here. We appreciate it. And Pam Wolf, thank you so much for your help and your time and your presentation. It was great.
It was my pleasure. Thank you so much for having me.